Does someone with a court-approved domestic violence restraining order have a Second Amendment right to possess firearms? It's a controversial question, I know, and it's one the Supreme Court just announced it would be answering during its next term. But that's not the only case the justices agreed to hear. They are also likely going to take up a controversial tax case that could give billions of tax dollars back to big corporations and could change Congress's taxing powers. Now, I told you all about that case in the video that's right after this one. But first, let's talk about this gun case. The case is called United States versus Rahimi. Rahimi is Zaki Rahimi from Texas, who had a court-ordered restraining order against him for allegedly assaulting his girlfriend. Both federal and Texas state law bans people with domestic violence restraining orders from possessing guns. Well, after that restraining order was imposed, Rahimi, according to court documents, was involved in multiple shootings in Texas. He was indicted by a federal grand jury for possession of a firearm while under a domestic violence restraining order. But he sued, saying the federal law that restricts him from having guns violates his Second Amendment right. And guess what? The Fifth Circuit Court of Appeals agreed with him. And you may be wondering, how did the appeals court get to that decision? Because of a landmark Supreme Court ruling last year in New York State Rifle and Pistol Association versus Bruin. In that case, the Supreme Court ruled it's constitutional to carry guns in public, and the court's conservative majority established a new test for when a gun law is constitutional. They called it the Bruin test. The Bruin test says a modern-day gun law must be consistent with the nation's historical tradition of firearm regulation. Basically, the test says in order for any modern-day gun law to be constitutional, those laws must have ties to gun laws from America's founding. They don't have to be twins, but they have to have some traditional roots. But that Bruin test has caused all kinds of questions and confusion in the lower courts because, of course, we know domestic violence laws weren't a thing in 1776, and neither were drug laws, for that matter. And it goes without saying, high-capacity firearms weren't even in existence back then. So this Rahimi case will give the Supreme Court its first chance to clarify how the Bruin test should work and how closely current gun regulations must mirror those that existed during the founding of America. The Supreme Court's new term begins in October.